Hi, this is Ed Sullivan and Marco Berti, and we're talking about retaliation and new cases. Mark, we're seeing a spate of cases dealing with people in the HR department filing claims of discrimination or retaliation or talking to their companies about those things, and there's a lot of little interesting nuances to those cases. Why don't you explain?
Oh, there are, and of course, when the HR manager brings a claim of retaliation, well, companies get scared because they know where the bodies are buried, the skeletons in the closet, that sort of thing. But in actuality, the law has developed a little nuance, like you said, that's very favorable for companies. What that nuance is the courts have said if an HR manager makes a complaint of discrimination that would otherwise be protected, it's not protected in their case unless it's clear from the context that they're not making that complaint as part of their job duties, but rather on a personal stepping outside their role as the HR person in their personal capacity. So you'll see numerous cases, and it's been extended to managers too. There's a Fifth Circuit case involving the FLSA, Hagen versus EchoStar, where an employee complained to the manager about some alleged overtime violations. The manager passed the complaint on. Then later on, the manager was fired. He sued for FLSA retaliation. The Fifth Circuit said, you didn't step outside your role as a manager. You were just doing your duty as a manager, as passing this information on. Therefore, you never engaged in protected activity. And we've got a paper on this on the website. And almost all the courts have accepted this line of authority. And it's really devastating to most HR managers' retaliation cases. Now, for those plaintiffs' lawyers out there, there are two cases, and they're in the materials, where they basically say, hey, these HR folks, they're supposed to be the canaries in the coal mine. If with their complaints and bringing up that evidence of the toxic fumes of discrimination to the company is not protected and the company can just kill the canary, well, that does grave damage to Title VII. And therefore, they're not going to file that line of authority. But the vast and overwhelming number of courts have followed that authority, and so it's something that, as the company, you really need to keep at your ready in defending these sorts of cases.